Hello and happy Wednesday. Welcome back to this channel. It is hump day, and there is a lot to get into. I mean, what is going on in them court filings? We're going to jump right into the case of It Ends With Never. There is so many filings to go over. It seems like, in my opinion, Blake Lively is losing it, okay? As other people have said, and not actually Golden mentioned, she is big mad. Let's talk about it right away. Grab your emotional support lip gloss. We are going in. You are in frame with Mandy Magnan. Before we jump into It Ends With Us, something else is happening that's very big today, and I would be ignorant in myself to not use my platform to say anything. Now, this isn't a political stance. This isn't, whatever you want to feel about it. But I have been following the Freedom Flotilla that is headed to Gaza. There's over 50 ships with more than 500 unarmed civilians trying to bring humanitarian aid to Gaza. And they are so close. But now it's been reported that at least 6 of the 50 ships have been intercepted, and it continues. So it's just very heartbreaking for me. It's a very heavy day. And yeah, I just wanted to bring that up, and I wanted to take a moment to pray and send love and just as much positive vibes or anything that I can send to not only the brave unarmed civilians trying to bring humanitarian aid to Gaza, but of course all of the people in Gaza who have been under the thumb of Isn't Real for so many decades, and really in the last year and a half. And at what point does everyone take a stand and say enough is enough? When? If not now, when? So I just wanted to take that time to give you a little bit of update that the ships are being intercepted, and it looks like, sadly, Gaza will not be getting the humanitarian aid that the Freedom Flotilla is just trying to bring them. You can follow them online at the Global Summit Flotilla Tracker or anywhere online. You could watch it live, but right now a lot of their ships are going off air, and they're in very, very serious need of attention and help. And I hope that all media outlets and everyone reporting any news, whether it be entertainment like we usually do on this channel or actual news, report on this, because all eyes need to be on the flotilla as well as on Gaza. And at this point, if you can't say F isn't real for what they've done and what they continue to do, and the hold that they have within the North American governments and the hold that they have on the world, I don't know what else to tell you. In my heart of hearts, I know that they, with Turning Point USA, had something to do with the assassination of Charlie Kirk. And thank goodness for Candace Owens that she is actually the one of the only people close to Charlie that is still investigating this and asking questions. They need to be stopped. And at what point, I don't know what else to say, but my heart has been very heavy today just watching the flotilla tracker and now seeing that ship after ship after ship is being intercepted by the Israel forces. And it's just really sad, because on those ships is dire humanitarian aid for the people of Gaza. So I just wanted to take this minute to say that they are in my heart, and hope that one day we can just all live in peace, and that our elected officials stop inciting violence and stop with all of this madness, and that one day Israel will be stopped and the people of Gaza will be free. Okay. With that being said, let's get into the court filings and talk about It Ends With Never. There has been some major developments in the last 24 hours, and things are just going banana cuckoo cray cray. Okay, yes, the New York Times has filed now a lawsuit independent. They are suing Now, Justin Baldoni and the Wayfarer people, we'll get into that in a separate video because it's a whole other thing. But I just want to talk about everything that was filed in the court of It Ends With Never, and also some rulings that the judge has made and a conference that will be happening. Okay, so let's just pull up the court listener and see what's going on, and we'll start and we'll just bang them out. And I'm sorry if I made anyone sad at the beginning there, or mentioning, the flotilla freedom float, or anything to do with, Gaza and the things happening there, the word that I'm not sure if I'm allowed to use or not on this video without it getting reported. But this is real life. This is going on. Okay, so I don't want it to weigh heavy on my heart, but what a luxury to be able to not do that. But it is, and I really thought this time with 50 ships and over 500 volunteers that they would make it, but no, they have not, and it doesn't look like they're going to. However, let's get into It Ends With Us, because just in the last 24 hours, oh my god, okay, oh my god, we left with the judge granting the depositions. Yesterday was a big day for depositions. We know for sure Van Zandt was deposed. We also know Josh Greenston was deposed, and Blake Lively was able to go first, and the depositions start at 8 a.m. Since then, we have Blake Lively's third attempt, third motion, third request for attorney fees, treble damage, and punitive damages. This is the third time she's put something in for this. Then we have a letter response in opposition addressed to Judge Liman. That's from Aline Garofalo. Then we have the declaration with that because, Blake's not happy. She wants more and more and more and more, which we'll get into. Then we have, what else do we have here? We have the court is going to review privilege logs, which we'll all talk about. There is Stephanie motherfucking Jones is in here. They want an extension. They want to depose. They're asking for another extension for the deposition of Jed Wallace. Then we have, again, so then there's the amended categorical privilege log. Then there's a joint stipulation, and that's for, again, Jed Wallace from Stephanie motherfucking Jones. Then there are some things, very interesting things that have been filed by Blake Lively, and that's for an extension of time, as well as to answer the judgment of pleadings that the Wayfarer asked for. And basically, she's just being Blake Lively. So let's just bang them out, shall we? One by one, because let's go here, Blakeski. This is Blake Lively's third memorandum in reply asking for motions for attorney fees, treble damages, and punitive damages. So Wayfarer people had responded to the newest one. And what I think is just so funny is the Wayfarer people have also submitted things like, can we go back to Steve Solritz's secret recording? Where is that? Why isn't it uploaded? Why isn't it unsealed? But anyway, this is Blake Lively again asking for the same treble fees. Now she's fighting. And it's just so funny that she's fighting for this at the same time that the New York Times is filing their lawsuit, which I just find collusion. But that's just me. It seems like, in my opinion, as soon as Blake Lively, if she is granted this treble damages and attorney fees, she's going to pull her case. I think they found things in the depositions, and it's probably not looking good for her. Okay, that's what I'm thinking by this kind of like little meltdown. Okay, this is just one of the meltdowns presented by Blake Lively. Again, her third time for the treble damages and attorney fees. This is what it says. The Wayfarer parties brought a meritless defamation action in New York under California law, using California-based attorneys representing a California company based in large part on a complaint Ms. Lively filed with the California Civil Rights Department. The court dismissed the Wayfarer parties' lawsuit against Ms. Lively, including their defamation claim and every other claim they alleged. That's not true. There are still 3 claims that they could have reamended and refiled. So even right there, I'm like, I don't know. There's, twisting the truths, and then there's like flat out lying. Like, I think the judge knows that he didn't dismiss every single claim that they had, but okay. They now seek to repudiate their invocation of California law to avoid the consequences of their failed litigation strategy. They advanced 3 arguments for why the court cannot or should not rule on Ms. Lively's motion, all of which fail. First, the Wayfarer parties suggest that the court cannot rule on Ms. Lively's motion because it presents issues of first impression under Section 47.1, including ill-defined constitutional concerns and conflicts. It goes without saying that this court has the authority to rule on matters of first impression, including Ms. Lively's motion, especially when, as here, the Wayfarer parties' own claims and litigation conduct before the court have put 47.1 at issue. I just want to say straight off the bat, Blake, even taking what you said as true, every single thing that you said as true, which already has been debunked, already has been proven not true, that you've been lying, and you've been lying about a bunch of stuff, and you colluded with the New York Times, and you obtained illegal text messages before creating a fake lawsuit in order to get those text messages. Why should you be the first for 47.1 out of everything, out of all of the survivors and victims? You think what happened, do you know, I'm not trying to put victim against victim or, survivor against survivor, but girl, it ain't even that serious. You even said yourself to Megan Twohey that you've been through far worse. Not negating if this did happen that it's bad, but give me a break. Do you know what I'm saying? Give me a break. Okay? Survivor to survivor. You feel me? That's all I'm going to say about it, because this shit pisses me off big time. Second, the Wayfarer party's argument under Section 47.1 does not apply extraterritorially where Miss Lively is not a California resident and the film was shot outside of California is similarly meritless. None of the Wayfarer party's case law addresses application of a state's law when the party resisting application itself brought claims under the state's law. Even if they did not invite application of 47.1 upon themselves, which they did, there exists a sufficient nexus between California and the Wayfarer party's retaliatory defamation action based on Miss Lively's California CRD complaint, the only conduct relevant here to justify its application. Third, the Wayfarer parties argue that the court cannot apply Section 47.1 without factual findings that Miss Lively acted without malice and had a reasonable basis to make her complaint about harassment and retaliation. It's like they don't even argue the fact that she did this with malice or without malice, or that they're just like, well, even if she did, that's what I get from their argument, honestly. In effect, the Wayfarer parties argue that the court cannot conclude that Miss Lively is the prevailing defendant in the defamation action, which has now been dismissed with prejudice or abandoned in its entirety. Instead, they argue Miss Lively must endure a jury trial to prove that she already prevailed. This makes no sense and runs counter to the California legislators' express intent to provide remedies to a successful defendant at the earliest stages, typically through a motion to dismiss. So she doesn't want to go to a jury? It literally says Miss Lively must endure a jury trial to prove that she already prevailed. Okay. In a perverse twist, the Wayfarer parties attempt to justify the exact type of protracted litigation the statute was designed to curb by arguing that Miss Lively's affirmative claims, with which the Wayfarer parties' separate lawsuit had previously been consolidated, present the same factual issues as her motion under Section 47.1, and thus must be decided together to avoid inconsistent rulings. This is wrong. Miss Lively claims do not necessitate Miss Lively to prove that she acted without malice. So they're saying that, we don't need to prove it was out malice without you giving us what we want, which is triple damages. What? The Wayfarer parties did not allege otherwise in their lawsuit and should not benefit from the fact that Miss Lively's affirmative claims remain standing. Finally, the Wayfarer parties argue that Miss Lively has not established a basis upon which the court can calculate triple damages and cannot establish her right to punitive damage absent a factual finding from a jury. Not so. Miss Lively has already requested a schedule to introduce evidence of her actual damages, which will be established by the close of expert discovery on November 14th, and which the court can then treble. Moreover, California President confirms that a judge may award punitive damages under California Code Section 3492. So that's what they want. They don't want this to go to a jury. They want Mr. Zaddy, Judge Lyman, Mr. Lyman, Zaddy, please, Daddy, don't make me go to a jury. You have the power. It says right here. Moreover, California confirms that a judge may award punitive damages. That's what they want, and they bring it up a couple of times. Indeed, that authority should apply with greater force, whereas here, the malicious, oppressive, or fraudulent conduct is the wayfarer party's litigation conduct, which is evident on the court's own docket. The wayfarer party should not be permitted to avoid the consequences of their retaliatory litigation tactics any longer. The court can and should rule on Ms. Lively's motions at this juncture and set an evidentiary hearing to establish Ms. Lively's attorney fees and damages. Then they go into Section 47.1 and how it doesn't infringe on the wayfarer party's constitutional rights. The wayfarer party's suggestion that this is somehow improper for this court to rule on Ms. Lively's motion, since California courts have yet to interpret Section 47.1, is incorrect. This court is plainly empowered to interpret Section 47.1, where the wayfarer party's own litigation conduct implicated it. And the court expressly allowed Ms. Lively to renew her arguments thereunder. If the wayfarer parties did not want to face the consequences of California law, they should not have invoked it in the first place and on multiple occasions thereafter. The wayfarer parties also assert that this court cannot rule on Ms. Lively's motion because it presents issues of first impression, including constitutional concerns and conflicts. Then it does say here in the footnotes that the wayfarer parties mischaracterized the court's prior ruling, saying that the court denied relief under Section 47.1. In fact, the court did not reach the issue and expressly allowed Ms. Lively to renew these very arguments. The wayfarer parties' Noer-Pennington challenge bears bones as it is, fails to raise free speech concerns. The Second Circuit has not decided whether Noer-Pennington even extends to non-commercial litigation. And even if it did, it would not extend to Section 47.1, which itself exists to protect First Amendment protected conduct. Further, a defamation claim is not itself a constitutional right. The elements and scope of the claim may be limited by common or statutory law, as discussed further below. Moreover, any risk that 47.1's treble damages provision would chill petitioning activity in the form of defamation suits is outweighed by the risk. That retaliatory defamation suit would chill reports about sexual harassment. Finally, even if Noer-Pennington applied to Section 47.1, the wayfarer party's case would fall under an extension of the sham exception as a baseless abuse of judicial process based on the patent deficiencies in their now dismissed claims. Numerous exceptions to the litigation privilege has been recognized based on irreconcilable conflicts between the privilege and the other co-equal state laws, such as perjury, false report of a criminal offense, and discipline of attorneys who engage in solicitation. Based on this principle, Section 47.1 clearly reflects the California legislature's intent to carve out an exception to the litigation privilege to deter retaliatory defamation actions based on reports of sexual harassment and retaliation. Nor is 47.1 an outlier. California courts have long carved out exceptions where the privilege would otherwise shield wrongful conduct. For example, as the wayfarer party's own authority confirms, California recognizes an exception for malicious prosecution claims. In any event, many of the public communications on which Ms. Lively's motions relies are not privileged at all, including, for example, Steve Sorit's and Brian Freeman's out-of-court statements. For the litigation privilege to apply, a communication must bear a functional connection to the litigation. The communications must function as a necessary or useful step in the litigation process and must serve its purpose, and cannot merely advance parallel interests such as vindication in the court of public opinion. what I think it is so wild, the fact that she keeps bringing up the things that Steve Sorrett said about how, he's going to spend tons of money to make sure that Blake and Ryan don't get away with it. He's going to protect the Wayfarer studios. Of course he's going to. But also, let's go back to what your husband, Ryan Reynolds, was saying. He literally got Justin Baldoni fired from his agency, calling him a sexual predator all over town. So it's fine for him to do it, but it's not fine for Steve Sorrett to say that he's going to defend Wayfarer Studios. And where's that secret recording? Because I'm not going to forget about it, just like I'm not going to ever forget about Van Zandt. Okay, number one, you're guilty, you're guilty, you're guilty, Blake. You made all of this up. It's so crazy how we got here, and they're grasping on anything that they can. Accordingly, courts consistently hold that certain public statements, like those addressed in Ms. Lively's motion, fall outside the privilege. Finally, the Wayfarer party's assertion that a jury must determine malice under Section 47.1 fails, where the facts are undisputed as they are here, given Ms. Lively is undeniably the prevailing defendant in the failed defamation action. The applicability of a privilege is a question of law. Then they do go into the Wayfarer party's extraterritorial argument and how it's meritless. And because, the New York, and they're in California and she's in New York, and they say that none of the cases cited by the Wayfarer parties address application of a state's law that the party opposing application itself invoked. And then it does say here, which I said on the live that they were going to use this, is that her loan out agreement also contained California choice law. And I mean, that is a good thing. That is something to fight. I knew that they were going to bring that up. Rather, their authority involves cases in which a defendant is sued in California and argues against extraterritorial application of a California statute to out-of-state parties or for conduct that occurred outside of California. Here, the Wayfarer parties intentionally brought suit in New York under California law for their own benefit and now argue that California law should not apply to them in the same litigation. This position is absurd and must be rejected. The Wayfarer parties principally argue that there is no such connection because the film was shot outside of California and Miss Lively is not a California resident. This misses the mark. The relevant conduct here is the Wayfarer party's retaliatory litigation based on statements contained within Miss Lively's complaint to a California agency, not the sexual harassment and smear campaign allegations underlying Miss Lively's affirmative claims. And to the extent the Wayfarer parties concede that the filing and dismissal of their claim is relevant, those claims are clearly tied to California. It is undisputed that the Wayfarer Studios LLC is a California-based company which retained California-based attorneys to file a defamation action under California-based law, in principal part on allegations made in Ms. Lively's CRD complaint. Finally, strong public policy considerations weigh in favor of applying Section 47.1. Strong public policy? Who's in favor? No one's... I don't know about all those amicus briefs you paid for, but I would say that the strong public policy is that we're not in favor. We're not in favor, okay? The California legislature enacted Section 47.1 to protect victims of sexual assault, harassment, and discrimination, and to ensure that perpetrators cannot misuse litigation as a tool of intimidation and retaliation, allowing the Wayfarer parties to invoke California law as the basis for their affirmative claims against Ms. Lively in New York while simultaneously disclaiming its protections for Ms. Lively would subvert that legislative purpose and strip Section 47.1 of its intended force. Oh my gosh. I don't know. I got a lot of arrows here. I don't know what's going on. Factual findings as to Ms. Lively's affirmative claims have no bearing on whether Section 47.1 applies. So, true or not? That's what she's saying. Factual findings, that doesn't matter. That doesn't matter, okay? Whether it's right or wrong, whether I have truth or not, whether I have facts or not, whether it's all BS or truth, it doesn't matter. That's what she's saying here. The Wayfarer parties further assert that the court cannot rule on Miss Lively's motion until a trier of fact determines that Miss Lively acted without malice in communicating about the Wayfarer party's sexual harassment and retaliation, and that Miss Lively had a reasonable basis to report her concerns about the workplace. The court's dismissal order, which holds that Reynolds, Sloan, and the New York Times did not act with malice, including because Miss Lively gave them no reason to doubt her version of events, only bolsters this conclusion. To insist Miss Lively reprove these facts at trial would cut Section 47.1 off at the knees. The California legislature made clear that Section 47.1 remedies must be available at the earliest stage to prevent protracted litigation that would re-victimize complainants. Forcing Miss Lively to endure a jury trial to establish what is already plain from this court's own rulings would run contrary to the statute. She does not want to go to a court. I'm telling you right now, she does not want jury. She does not want this to go to court. And I think that's why they're fighting so hard to get all the money back so that she can call it a day. I just have such a gut feeling that she wants to get triple damages and wants to get all of her money back so she can end this. I don't think she wants to go to court. And it says right there in purple, forcing Miss Lively to endure a jury trial to establish what is already plain from this court's own rulings would run contrary to the statute. Nor did the Wayfarer parties attempt to muddy the waters by claiming that Miss Lively's Section 47.1 motion presents the same factual issues as her affirmative claims withstand scrutiny. Whether Miss Lively acted without malice to make her complaints is not a necessary element of her affirmative claims. They're literally saying it to us. Like, this is some of these letters are some of the craziest things I've read so far, because what are you talking about? What are you saying? Whether Miss Lively acted without malice doesn't matter to her claims? Yeah, it matters. Like, it matters. Whether you acted with or without malice matters, Blake. You know? Miss Lively does not have to prove that she made a complaint at all to prevail in her sexual harassment claims. I can't make this up. This literally says it. She does not even have to prove it. She does not have to prove that she made a complaint at all to prevail in her sexual harassment claims. As for retaliation, Miss Lively only must prove that she engaged in a protected activity, that she opposed unlawful harassment. The Wayfarer party's contention that Miss Lively must first prove her entire retaliation claim imposes an unwarranted burden on Miss Lively, especially where the Wayfarer parties have already admitted they believed Miss Lively made her complaints in good faith. Show me where they said that. Show me where they said that. Show me ever where they agreed that, oh yeah, you know what, yeah, she did. It was true. We think that she did that. No. How about no? How about there are dozens of text messages between the Wayfarer parties saying that they know exactly why she's doing this, and it is to hijack the movie. What? Then they go on to this little quote, and I love the way that they just twist this. Referencing a text message exchange between Mr. Baldoni and Miss Nathan, in which both argue that Miss Lively genuinely believes she's right and that all of this is unjust. And this court has already recognized the strength of the evidence in favor of a smear campaign. The text message between Justin and Melissa Nathan was literally Justin being like, I know the type of person Blake Lively is. She's not going to stop. She's the type of person that genuinely believes she's right. It's the only thing, the only insult, if you can call it an insult, that Justin Baldoni has that he said about Blake Lively. And they've been using it every single chance they get. But now they're just flipping it on their head. And they're trying to say that he said that. I can't even believe what I'm reading. It's so crazy that he said that because she was right in filing this complaint, in complaining. That's not what the text is about at all. And they know that. And they've used this quote, this text message from Justin Baldoni, so many times. And now they're trying to flip it on its head and twist the truth of that text message. It is nuts, okay? I think this is so crazy. Miss Lively is entitled to actual treble and punitive damages. Finally, the Wayfarer party's contention that the court cannot award treble damages because Miss Lively has not yet established her actual damages fails. Indeed, Miss Lively seeks a schedule for the submission of damages evidence, which the court may then treble under Section 47.1. Further, contrary to the Wayfarer's position, California courts hold that the judge or jury, as the case may be, has the authority to decide whether and what amount of punitive damages should be awarded. They want the judge to rule on this so that they don't have to go to jury. I 100% believe right now some things happen in the deposition and they're in deep water. That's just what I'm feeling, okay? The court is therefore fully empowered to determine the application of punitive damages at their juncture. If the court concludes that further evidence is warranted, Ms. Lively seeks a brief evidentiary hearing on these discrete issues, which should be held separate from the trial of Ms. Lively's affirmative claims to avoid confusing the issues or the jury and to provide Ms. Lively with the prompt relief the California legislature intended. I'm having a really hard time today saying a few words. I'm not sure why, but legislator is like, what's going on there? I'm going to have to work on that. But anyway, that's it. Okay, for the foregoing reasons, the court should grant Miss Lively's motion in its entirety. Oh, I bet, as your husband, I bet you want that. But absolutely unbelievable. They want the judge to do it. Of course, Judge Lyman, you know. Please, Danny, please. Now, moving on next, we have Aline Garofalo here, and she's just trying to explain these signal messages that Blake Lively filed motion to compel, all these signal messages saying there was like 4,600 signal messages that they didn't give us, and then there's all these people, and we want them, and then the Wayfarer people came back and were like, here's a privilege log, these communications are privileged. It's still not good enough, okay? Blake Lively still doesn't think it's good enough, okay? So she just explains how they've been going back and forth ever since the summer. Do you know what I mean? I mean, this all started in February with Blake Lively's first amended complaint. Then the Wayfarer parties did so. They followed the court order to submit a categoric privilege log pursuant to Rule 26(2)(c). The Wayfarer parties did it. On September 9th, Lively requested to meet and confer about the privilege log, which occurred on September 10th. During that conference, Lively requested that the Wayfarer parties, 1, provide additional information about the basis for asserting a privilege over communications that included defendants Jed Wallace, 2, provide additional information about the basis for assertions of privilege over communications that included Spencer Freeman and Jared Freeman, and 3, amend their categorical privilege log to reflect the number of documents withheld within each category. In response, the Wayfarer parties informed Lively that defendants Jed Wallace and Street Relations, Inc. were represented in connection with this matter by counsel for the Wayfarer parties and pointed them to the already produced retainer agreement executed by Mr. Wallace in December of 2024. The Wayfarer parties further informed Lively that Spencer Freeman and Jared Freeman were law clerks assigned to work on this litigation. Finally, the Wayfarer parties agreed to produce another privilege log identifying the number of documents withheld, and they did so on September 15th. The Wayfarer parties then produced an amended categorical privilege log showing approximately 4,600 signal chats. The Wayfarer parties, however, alerted Lively that this number did not actually reflect the numbers of signal chats as it included each attachment as a separate document. In other words, a single signal thread that attached 5 images would be counted as 6 documents. Similarly, where multiple recipients were included in a particular signal chat, the identical document would have been collected from each of those recipients. Therefore, if 5 custodians participated in the same chat, 5 copies of the chat would be included in the total of privileged documents. Due to the abbreviated time frame in which Lively demanded an amended categorical privilege log, the Wayfarer parties were unable to provide a count of the individual deduplicated signal communications withheld on the basis of privilege, a time-consuming undertaking requiring manual re-review of documents already determined to be privileged. There are under 300 privileged communications during the relevant period. The fact that she is running to the courts for 300. Do you think you've already got 80,000 plus documents in September. You got so many more over the summer. You got so many things. These 300 privileged communications is supposed to what? They're going to prove your whole case? Give me a break. The Wayfarer parties have also re-reviewed communications involving Jared Freeman and Spencer Freeman without attorneys as participants. There are 3 such documents that were withheld on privilege ground. All 3 relate directly to the preparation of legal documents in connection with this litigation, with which Jared Freeman and Spencer Freeman were instructed by attorneys to assist on. Moreover, Lively never informed the Wayfarer parties that she intended to move to compel a document-by-document privilege log, nor asked the Wayfarer parties their position. By failing to identify the relief she now seeks and to give the Wayfarer parties an opportunity to respond, Lively failed to meaningfully meet and confer as required by Rule 4C of this court's individual practices, and the court should deny the motion on that basis alone. Lively not only failed to meet and confer as the court requires, but also fails to articulate any basis for requiring a document-by-document identification and description of the Wayfarer parties' privileged signal communications. Further, although Lively has repeatedly demanded additional information with respect to the Wayfarer parties' original and amended categorical privilege logs, she has failed, despite repeated requests, to specify the additional information she seeks. She just wants it. She doesn't know. She just give me. I don't care. She obviously doesn't care about any privilege. She doesn't care about attorney-client. She's already subpoenaed the opposing counsel, every single person at the law firm at one point, over 107 content creators. Her reach knows no bounds, okay? She does not care. She just wants it. Lively misrepresents the Wayfarer parties' position by stating that the Wayfarer parties declined to provide additional information. On the contrary, the Wayfarer parties repeatedly asked Lively to specify what additional information would satisfy her demands, but had been repeatedly rebuffed. The Wayfarer parties produced a categorical privilege log mirroring those produced by others in this litigation. The Wayfarer parties provided more information in some instances, including by amending to specify the number of documents withheld, even though Local Rule 26.2 does not require doing so. Lively relies on her theory of an ongoing retaliation campaign against her as justification for probing into communications protected by attorney-client privilege during litigation, despite having never produced any evidence that such a campaign existed either before or during this action. Right. Where's the evidence? At this point, where's the evidence that it even happened? You haven't proved a shred. You haven't proved even 1% of your case yet, and still you think that you deserve all the attorney-client communications. Unbelievable. Nevertheless, the Wayfarer parties are willing to provide a further amended categorical privilege log that subdivides the privileged signal communications into categories by the participants in each group of communications. If additional information about the description of those groups of communications can be provided without waiver of attorney-client privilege, the Wayfarer parties will provide it. Requiring the Wayfarer parties to do more would flout the decision in this district, holding that parties need not provide a privilege log for post-litigation communications at all, let alone a document-by-document privilege log. Even if documents dated post-complaint are relevant, that party need not individually identify each privileged communication created in connection with the litigation, given that once litigation begins, most communications are privileged. I'm just still blown away that she's able to get away with this time and time again. And I'm just, it's so gross. But this is the declaration from Teresa M. Troopson, and this is in support of the opposition of the thing that we just read. And there was just a couple of things here I found interesting. During the September 10th call, so I guess this lady, Teresa, is the one handling the privileged log and the fight against this, which everything is a fight against Blake Lively. Everything is a fight, okay? During the September 10th call, counsel for Lively made 3 specific requests with respect to the categorical privilege log: that the Wayfarer parties provide additional information that include Jed Wallace, They provide additional information about the basis for asserting privilege over Spencer Freeman and Jared Freeman, and they amend their categorical privilege log to reflect the number of documents withheld within each category. Then they did say that they told them, like, obviously Spencer Freeman and Jared Freeman are working law clerks at their dad's firm or uncle's firm or whatever it is. Like, give me a break. Then it does say, during the call, counsel for Lively demanded that the Wayfarer parties provide unspecified additional information about the documents withheld based on privilege. I repeatedly asked them to clarify what additional information they demanded, but they did not offer any explanation. Since then, my co-counsel and I have repeatedly asked for clarifications and have been rebuffed. This resulted in the appearance that many more communications were withheld for privilege than was the case. However, Lively raised no objection at the time. So they just said it looks like it's 4,600, but when you break it down by how many people are in there, like let's say there's 10 people in the one group chat, that's 10 different documents. Let's say there's 30 chats in that thing, that's like 10, who's doing math right now? But y'all know, y'all can follow me, right? So she already knew that before she went and filed in the courts, okay? Before she went and filed her motion to compel, they already explained all of this to her, and there's emails going back and forth between them. And now I guess they're still going over Brianna Butler Coslow and Catherine case. I thought this was shut and closed last week, when he already went over all of their privilege logs and documents. And, there was like documents in there with her dad and, oh my gosh, like just stuff that it's like, okay, Blake, you can have it. But I guess he's gone over them again. And he's also went over the Wayfarer and Wallace parties' privilege logs. And he made an order that we're not going to be able to see. Okay, it's court access only, but he emailed them. And the court is directing those portions of the documents to be withheld on grounds for attorney-client privilege, and all other materials must be produced by October 6th. So we'll see. We don't know here what he granted and what he denied, what he granted for Wayfarer, what he denied. Doesn't say. So it just says it's for those docket numbers, and he went over them. He denied some, granted some. So I don't know. And now you have Stephanie motherfucking Jones coming in here. What does she want now? What does she want? Oh, she wants an extension too. Oh my God, they all want extensions. So on July 9th and 15th, in 2 cases captioned above, the court amended the case management plan scheduling order. I wonder why they did that, because Stephanie Jones and Blake Lively asked for it, not Jed Wallace, not the Wayfarer people. No, it's always been Blake Lively and Stephanie motherfucking Jones asking for an extension, and they always do it together because, birds of a feather. But they asked for the extension of deadlines, and it was done. The completion of depositions was supposed to be yesterday, whereas Stephanie motherfucking Jones, okay, she is asking the court. So anyway, she goes on about how Blake Lively got a 10-day extension for defendants Steve Soretz, Jamie Heath, Justin Baldoni to October 10th. Miss Lively and the Jones party and Jed Wallace and Street Relations have engaged in extensive conferrals to identify a mutually agreeable date for the deposition of Mr. Wallace, seeking to accommodate both the crowded deposition schedule in late September and early October. Miss Lively and the Wallace defendants have identified and agreed to proceed with the deposition of Jed Wallace on October 9th at the offices of their counsel. But no, not the 9th, is it, Stephanie motherfucking Jones? Miss Jones and the Wallace defendants have identified and agreed on October 10th as the most convenient date that accommodates the competing considerations set forth above, and for the convenience of the parties and witnesses, Mr. Wallace's deposition by the Jones parties can occur on a day adjacent to Miss Lively's deposition of Mr. Wallace. Whereas good cause exists to modify the existing case management plan and scheduling order to permit this deposition to proceed on October 10th, in light of the numerous other depositions in this case that have been scheduled for late September and early October, while the Jones party and the Wallace defendants sought to identify a mutually agreeable date that could accommodate that availability. Great. So now she also wants an extension, which is so crazy because when the waivers asked for one extension for Taylor Swift, oh my gosh, it was like the end of days, okay? But, oh, these girlies. Well, I guess the judge came back for that motion to compel, the one that we were just talking about with Blake Lively. I thought that was in the last order when it talked about Brianna case and Case Butler and, you know, those girls that we just talked about, Brianna and Catherine Case, those girls, okay? Plaintiff Blake Lively. So this is when we're talking about produce the document by document privilege log for signal communications. Oh my gosh, there's only 300 allegedly from the Wayfarer parties. That's what they say. The Wayfarer parties have represented that they are willing to provide a further amended categorical privilege log that subdivides the privileged signal communications into categories by participants in each chat. They have further indicated that if additional descriptions of those chats can be provided without waiving the attorney-client privilege, they will do so. The Wayfarer parties should also re-review the documents at issue in light of the court's recent rulings on privilege to determine whether additional messages can be produced. An amended categorical privilege log shall be served by October 6th. The court reserves judgment on Lively's motion pending service of an amended privilege log and the production of those messages that, after further review, can be produced without waiving privilege. So they're going to have to do extra work, even though the Wayfarer people in Aline Garofalo was like, what you're asking for is so burdensome. It's not being done with any other party. Like, it's just so much work. Like, why do we need to do it? They've provided us with privilege logs. We didn't ask for that. Kind of like, that's what she's saying. Like, why us? But the judge was like, oh, well, you said you do it, so do it. You have until October 6th. And he's also come back with the Jed Wallace thing to Stephanie motherfucking Jones, blah, 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 blah. It says all of this crap. And then it says, the Jones party and the Wallace defendants have identified and agreed on October 10th as the most convenient date that accommodates the competing considerations set forth above. And for the convenience of the parties and witnesses, Mr. Wallace's deposition by the Jones party can occur on a day adjacent to Miss Lively's deposition. Whereas good cause exists to modify the existing case management plan and scheduling order to permit this deposition to proceed on October 10th in light of numerous other depositions in this case that have been scheduled for late September and early October, while the Jones party and the Wallace defendants sought to identify a mutually agreeable date that could accommodate that unavailability. Now, therefore, it is hereby stipulated and agreed by and among the Jones party and Wallace defendants through their undersigned counsel that the Jones parties may take the deposition of Jed Wallace on October 10th and not to exceed 4 hours. And then, of course, they give the address of where it's going to be because the only privacy that matters is Blake Lively's. And this is the one. This is the one that really got me. So this is, oh my gosh, guys. We all know the day that we were waiting for Wayfarer to file the motion for judgment on the pleadings. This motion is just on the law. It has nothing to do with facts, true, not true. It's literally taking everything that Blake Lively said as true. Does it still fall under the law? If not, it should be dismissed. This is a motion for judgment on the pleadings. Well, Blake Lively and her people are peed off. They are not having it. They don't even want to answer it. They're saying, no, thank you. Please, judge. We don't have time for this. We don't want to answer it. And it is just a nutty letter. They title this letter Motion for Extension of Time for the Wayfarer defendant's motion on judgment of the pleadings and other relief. Let's just go through it. It's not even, honestly, I thought they were going to give us a whole bunch of, I thought it was going to be very long. I thought they were going to reply back with so much fluff and so much crap, but they are like, we don't have time for it. Please, judge, make this go away, or can we answer this at a later time? It's actually cuckoo bananas. This is just so nuts. Pursuant to Federal Rule of Civil Procedure 12C, Plaintiff Blake Lively respectfully requests that the court deny the Wayfarer defendant's motion for judgment on the pleadings. Just deny it. Can you just deny the whole thing? Because look, we don't want to do it. We don't have time for this, okay? As untimely, without prejudice to the Wayfarer defendants raising the arguments therein a motion for summary judgment or at trial. In the alternative, pursuant to Rule 1D of the court's individual rules and practices, Ms. Lively respectfully moves for an extension of time to and including October 27th in which to respond to the Wayfarer defendant's motion. We'll get to that because she wants an extension to reply. But yet you're replying right now. but no. You're telling me with your thousands of lawyers, your big team, you're with the biggest law firms, y'all don't have time to reply to this. Y'all really? Because there's some days where you submit 20 filings in the court. Look at all the stuff I just read. That was all you. So I'm like, what are you talking about? You have so much time. You filed now 3 times for the treble damages and attorney fees. You got the time, and your lawyers have the time, okay? To be clear, Ms. Lively is prepared to respond to each of the Wayfarer defendants' arguments at the appropriate time, whether that be at the summary judgment stage or at trial. Judgment on the pleadings and summary judgment are 2 completely different things. There is no point to get to summary judgment if you get dismissed at judgment on the pleading stage. Now, judgment on the pleadings is just taking the pleadings themselves, no outside evidence, no nothing like that, and saying whether the law is true. Does the law allow relief for this? If not, then it should be dismissed. In summary judgment, you can bring in depositions, affidavits, documents, everything that you're getting, any kind of evidence that you've gathered to prove whether or not your case stands or doesn't. They're not arguing summary judgment right now. They're arguing the judgment on the pleadings, but she doesn't want to do that. She just wants to have this waived until it goes to summary judgment. But to be clear, Ms. Lively is prepared to respond to each of the Wayfarer defendants' arguments at the appropriate time, whether that be at summary judgment stage or at trial. But why get all the way there if it doesn't work? Like, if you're not standing on any legs, then it shouldn't get to summary judgment. It shouldn't get to trial because there's no basis in law even for what you're trying to ask for what you are trying to sue in your complaint. So it's like, hello. But the Wayfarer defendant's decision to sit on these supposedly meritorious arguments for nearly 9 months means that briefing and adjudicating them now would only lead to duplicative briefing and waste judicial resources, and would force Ms. Lively and the court to bear the burden of the Wayfarer defendant's delay. Your trial isn't until March. You just ended depositions on the 30th. This is the perfect time to ask for it. This is the perfect time. Tellingly, although each of the Wayfarer defendants' arguments have been available to them since the outset of the case, and although their counsel alluded to the possibility of a motion for judgment on the pleadings on the record at the conference held on July 30th, the Wayfarer defendants waited to file their motion until the response deadline would fall on its last day for depositions in this case, knowing full well that because of their own discovery deficiencies, Ms. Lively's counsel would be preparing for and taking the deposition of 4 of the defendants during that period. Meanwhile, by the time the Wayfarer defendant's motion is fully briefed, the deadline for summary judgment motions will only be days away, meaning that each of the fact-bound challenges to the pleadings raised in the motion will be overtaken by the record evidence at the summary judgment stage. But if it doesn't get to the summary judgment, because it doesn't matter if it's not based in if you don't have the law to support you, it shouldn't even go any further. It does say in a couple of footnotes here that I found very interesting. To take just one example, the motion asserts that Ms. Lively has failed to exhaust her admin remedies against It Ends With Us movie. Motion at 16 to 18. But the burden of pleading and proving Title VII exhaustion lies with defendants and operates as an affirmative defense. Not only does that render this argument inappropriate for resolution on a defendant's Rule 12 motion, It Ends With Us movie did not even raise this affirmative defense in its answer. In other words, not only did It Ends With Us movie move for judgment on the pleadings based on an affirmative defense, it had not pleaded. But because of that failure, Ms. Lively would be entitled to judgment on this particular defense, not It Ends With Us movie. In any event, and further demonstrating the wastefulness of the Wayfarer defendant's motion, Ms. Lively amended her CRD complaint and received a right to sue letters with respect to It Ends With Us movie during the pendency of this action. as is well established in this district, that is sufficient. I wonder when they did that, because they didn't attach it. Oh, it continues. It continues. This is such a this is one of the biggest load of craps I've ever seen. They should have done way better. Like, they needed to do way better than this. The question at this stage of the case is not what the pleadings allege, but what the evidence shows. No. The question at this stage and what a motion for judgment pleadings are has nothing to do with evidence and everything to do with law. So even that sentence right there is like, what? What are you talking about? The question at this stage of the case is not what the pleadings allege, but what the evidence shows. And the appropriate means of answering that question is through a motion for summary judgment. Meanwhile, to the extent the motion raises purely legal issues that would not be affected by the summary judgment evidence, the Wayfarer defendants will suffer no prejudice from a few weeks' additional delay in briefing those issues. OMG, I cannot. It's always on her time. It's whenever she wants it. I cannot with these people. Then they go into the back and forth, the initial complaint, At the outset of this case, the court expedited the initial pretrial conference and asked the parties to submit a case management plan with deadlines that would enable trial to occur. Even with the handful of modifications that the court has granted in the months since, that goal remains in sight. Yeah, but why was there modifications in the case management? Because I believe the Wayfarer people were the only people that tried to oppose those extensions that Miss Stephanie motherfucking Jones and Blake Lively were asking the judge for. They make it seem like, oh yeah, we just did a little case management. There was like rescheduling because of you, okay? With a few exceptions, including a handful of fact depositions to be completed by October 10th, and we know now that that's all of the Wayfarer people. Expert discovery and scheduling to conclude on November 14th. Meanwhile, the current deadline for summary judgment motions is November 5th. Federal Rule of Civil Procedure 12C provides that a party may move for judgment on the pleadings after the pleadings are closed, but early enough not to delay trial. Again, your trial is in March. So now you're asking for... This is why I'm a little bit confused. This letter is to ask for an extension of time to reply. But wouldn't an extension of time delay it even more? Like, you know what I'm saying? So it's either like you don't want to delay, you want to answer, you don't want to answer. I think they didn't see this coming. I think they were fully preparing themselves to rebut the summary judgment by the Wayfarer people, and they did not expect a judgment on the pleadings. I think that they cornered them here, and they were not expecting this at all. Then it does say generally a Rule 12C motion is considered timely if it is made early enough to not delay trial. Okay? Trial, again, guys, is in March, okay? In March. There's a long time. Whether Rule 12C motion is timely is within the sound discretion of the judge. Oh, I bet it is, huh? The district court may refuse to hear the motion on the ground that its consideration will delay or interfere with the commencement of the trial. Consideration on the motion may still be appropriate if, unlike here, it seems clear that the motion may effectively dispose of the case on the pleadings. I love how they always put in like, judge, it's up to you. Judge, it's within the sound discretion of the judge. Judge, it's up to you. They did that in the last letter too. The district court may refuse to hear the motion on the ground that its consideration will delay or interfere with the commencement of the trial. Consideration of the motion may still be appropriate if, unlike here, it seems clear that the motion may effectively dispose of the case on the pleadings. But if the pleadings do not resolve all of the factual issues in the case, proceeding with discovery and potentially a trial on the merits would be more appropriate than an attempt at resolution of the case on a Rule 12C motion. Courts are unwilling to grant a judgment under Rule 12C unless it is clear that the merits of the controversy can be fairly and fully decided in the summary manner. The Wayfarer defendant's motion is untimely. Although all of the arguments raised have been available to the Wayfarer defendants since the initial complaint was filed, they did not raise them until September 26, 2025, measured against the court's stated goal of managing this case as to March 9th, 2026 trial date. That delay was excessive under Rule 12C. Again, there's still time. Why bring all of this to trial? Why bring all of this to a judgment, to a summary judgment, if there's still no basis in law for what you're bringing to the courts? I mean, if the judge can dismiss even 2 or 3 of the claims or 1 or 2 of the claims, bam, great, let's move on to the other ones, right? She's just, I don't know, it's just a funny, to me, a kind of cuckoo bananas funny letter. The motion primarily raises fact-bound challenges to the sufficiency of the SAC's allegations. Those arguments are meritless, but as far as the timing of the motion is concerned, they are more importantly all but mute. At this stage of discovery, Ms. Lively has uncovered voluminous evidence relevant to all of her claims. Rather than merely defend the sufficiency of the allegations to respond adequately to the motion, Ms. Lively would also need to make a proffer of the new and more detailed facts in her possession that would entitle her to amend her complaint should any of the Wayfarer defendants' arguments prove successful as to any of the SAC claims. The court would then need to re-evaluate that evidence under Rule 15's futility standard. Another one. She filed. She amended. She re-amended. Another one. Oh my gosh. How many chances do you get? How many chances do you get? Now she's saying, well, if you do allow this, well, just know I've got way more evidence and I want to re-amend. What? You don't get to re-amend after you go through all of the depositions and after all of that. You keep moving. There's stages that you keep moving on to. She's just asking, like, in my opinion, asking for too much. Either fight it or don't fight it, you know? Under Rule 12B plausibility standard, construing that evidence in Ms. Lively's favor along with the benefit of reasonable interferences therefrom. But crucially, that would be the same analysis as the summary judgment stage, when if the Wayfarer defendants chose to move against any of Ms. Lively's claims or defenses, she would then need to point to record evidence that construed in her favor and drawing reasonable interferences therefrom, and support a reasonable jury's findings in her favor. Considerations of judicial economy and common sense and the goal of holding to a March 2025 trial date. You meant March 2026. You meant March 2026, girl. Support conducting that exercise only once. I think the judge knows the difference between a summary judgment and a judgment on the pleadings. And this argument is kind of like, I think she's just like, well, why don't we just wait to the summary judgment? And it's like, nah, how about we go by the law and see if even the law is on your side before we even get to the evidence. The Wayfarer defendant's motion thus seeks a duplicative exercise that can only have the effect of causing delay. Meanwhile, the Wayfarer defendants will suffer no prejudice from having their present motion evaluated on the basis of the summary judgment evidence rather than the SAC's allegations. They have not sought to stay discovery or otherwise suggested that anything about the case schedule should change based on the filing of their motion. Yeah, because they don't want it to change. They don't need an extension. Why would they? By contrast, Ms. Lively will suffer significant... Oh, she's always suffering. By contrast, Ms. Lively will suffer significant prejudice from having to file what is effectively an opposition to summary judgment while discovery is still ongoing. Indeed, the only practical difference between the process for resolving this motion and a summary judgment motion filed at the appropriate time is that to respond to this motion, Ms. Lively will have to scramble to amass evidence from a discovery process that is and will be generating new evidence virtually every day between now and the response deadline. Wait a second, because didn't you just say that you uncovered tons of new evidence? You right up here, you just said, where is it? At this stage of discovery, Ms. Lively has uncovered voluminous evidence related to all of her claims. But then down here you say, Miss Lively will have to scramble to amass evidence from a discovery process that is and will be generating new evidence virtually every day between now and the response deadline. So you're still unearthing, They don't got nothing. They don't got nothing. And again, for your thousands of lawyers who get paid $8,000 to $10,000 an hour per lawyer, I think they're okay. I think you're going to be okay. I think you have the ability to answer to this appropriately and not deflect, okay? Including, they'll get evidence from depositions of Mr. Baldoni, Mr. Heath, Wayfarer, Mr. Soritz, Miss Nathan, and Mr. Wallace, not to mention the expert discovery process that will still be ongoing for several weeks afterwards. The court should accordingly deny the motion without prejudice to renewal of the arguments raised therein at a later stage, or exercise its discretion to hold the motion in abeyance until trial. So either dismiss it, or can we just not answer it? Can we just ignore it? Can we just put it aside? In the alternative, Ms. Lively respectfully requests that her deadline to respond to the motion be extended to and including October 27th, 3 days after the deadline to exchange expert rebuttal reports. Unless extended, the current response deadline is October 10th. This is Ms. Lively's first request for an extension of this deadline. I had to highlight that, guys. I had to highlight it because this is Ms. Lively's first request for an extension of this deadline. Yeah, of this deadline, bitch, because everything else, this is the first time it's been in the courts. This is the first time they filed a motion on the judgment pleadings. That's why this is the first time that you're requesting an extension. You've requested an extension for everything. They literally changed the entire case management scheduling plan because you requested it. You literally got extensions for depositions. You got an extension for Jed Wallace. You've requested an extension at every single stage of the game. But good thing that this is your first request for an extension of this deadline. Give me a break. Ms. Lively states that the Wayfarer defendants opposed the extension but did not provide any reason. For the reasons given above, even if the court is inclined to permit full briefing of this motion in the final days of discovery, such an extension would be warranted. Michael Gottlieb. And now I can go on and on and on about that letter, okay, about that little request for extension, but we got to move on, okay? We have to move on. Because what's the next thing? Blake Lively in the courts again. Now she wants a clarification on the deadline that request to admit is October 10th. So a request to admit is that you send the other opposing party or you send the other party a bunch of written statements that they either have to admit or deny. Okay, so you have to admit that, for example, the Wayfarer people can send, can you admit or deny that you never signed your actor loan out? Can you admit or deny? So it's kind of like that. So the responding party, they usually have 30 days to admit, deny, or explain why they can't admit or deny. And if they don't respond in time, the statements are automatically deemed admitted. Once admitted, those facts are treated as true for the case. So you don't need to prove them at trial. For example, I looked up kind of examples of this. And for an example is if you are suing someone for not paying rent, instead of proving basic facts in court, you can send them a request for admit, and it's something like, the questions would be like, admit that you signed the lease for apartment 3B, admit that the monthly rent under the lease was $1,200, admit that you failed to pay rent for July, August, and September. So then when you have those admittance on file, you've already locked in those key facts and as truth, so that when you get to trial, you only have to focus on the disputed issues like your defenses and stuff like that. So I don't know where this came from and why she's asking for this, but she wants clarification to see what the date is, because now that the depositions have been pushed back for the Wayfarer parties, she wants to know that are they going to now push back this as well. It's a good thing that in her last letter she wrote, she never asked for an extension of time on this deadline, but on everything else, and now including this, she's asking for it. So she just wants to see if the request to admit from September 30th she wants it pushed to October 15th. So to the extent of that court will provide any clarification or relief as to the request to admit, the Jones parties also request that equally apply. Yeah, of course they do. What one does, the other does, Pursuant to this court's initial case management plan, the deadline for the parties to submit requests to admit was August 14th, which was the same as the last day for depositions and that last day for fact discovery. While the court extended the fact discovery calendar to September 30th and subsequently extended the deadline for depositions to October 10th, the parties failed to expressly confirm with the court that the extension to the deposition calendar to October 10th likewise extended the deadline for requests to admit to the last day of depositions. For this reason, Ms. Lively seeks confirmation that the deadline for requests to admit is October 10th. I'm not really sure anyway why this is a big deal, but this is just a part of it, I guess. I don't know what they're going to try to get admittance for or what they're going to ask for, but they're trying to move it along, okay? To the extent that the deadline for requests to admit is not October 10th and instead is up September 30th as the last day of fact discovery beyond the depositions taking place through October 10th, Ms. Lively respectfully moves this court for an extension until October 15th to permit the parties to incorporate deposition testimony into the request to admit. Good cause exists for Ms. Lively's request for an extension of the current deadline to serve requests to admit. Good cause is likely to be found when the moving party has been generally diligent. The need for more time was neither foreseeable nor its fault, and refusing to grant the continuance would create a substantial risk of unfairness to that party. The parties have taken 12 depositions between Friday and today, and 4 more party depositions across 7 days of testimony are scheduled to take place between now and October 10th. None of this testimony could reasonably be incorporated in requests to admit, where the deadline was September 30th. Additionally, Ms. Lively continues to receive party productions as recently as last night. As well as I can't with her, okay? As well as anticipates third-party productions into next week as ordered by the court earlier today, which is what we just read for the October. They have until October 6th to send them the whatever, the privilege logs, the new privilege logs for like the 100th time. Further aligning the deadline for requests to admit with the last day of deposition testimony in both what this court initially ordered. The additional time for parties to serve requests to admit will contribute to the just, speedy, and inexpensive determination of the matter by narrowing disputed issues for trial, including those issues that await deposition testimony that has yet to be provided. So you guys can answer this, and you could want, to eliminate certain things by having these requests to admit, but a summary on the judgment pleadings is too much from the Wayfarer people. Further, to the extent the court clarifies that the deadline was September 30th rather than October 10th, and that deadline is not extended, Ms. Lively will suffer prejudice in being unable to obtain admissions from the defendants across a variety of issues that await party testimony. Notice how she uses these buzzwords and these trigger words. Suffer. What did she use in the other ones? Like, she's always using these little things that make it really seem that she is like the big old victim and continues to be victimized in this whole thing. So she's basically saying, Judge Lyman, Zaddy, if you don't extend it, I'm going to suffer prejudice, okay? This is the second extension that has been sought on the deadline for a request to admit. Yeah, by you. You forgot that part. While Ms. Lively intended to file a stipulation regarding the October 15th deadline earlier in the day on September 30th and received consent from the Jones parties, she waited over 14 hours for the Wayfarer defendants to respond by email that they do not consent to the October 15th deadline without providing a reason. Despite repeated attempts to secure their position during breaks of a party deposition, the Jones parties consent to this extension. The Wallace defendants take no position. Did it ever occur to you, Blake, that maybe they don't want to play ball with you and your people anymore because you're being bullies, you're mean, you're cray-cray? I think Elaine Garofalo told you pretty straight up in that last email exactly how y'all are being, and they will not yield to your insistent demands anymore. And it's possible that maybe they didn't hit you up after, 14 hours you had to wait for an email because they were doing multiple depositions in one day. Like, ew, boo-hoo. And now this is the very last thing that was filed, and it's just an answer to what Blake Lively, she put in this big whole crybaby thing, like, please no, ignore it, I don't want to answer it, we don't have time, this isn't fair. Well, here you go, because on Friday, October 3rd at 2 p.m., the parties will be provided with instructions for accessing the hearing via email. There will be a video conference via Microsoft Teams. The court will post an audio-only dial-in number on the docket for the public and press to access the hearing. Mic drop. So he's taking it. I mean, he's going to listen to their arguments on the judgment for pleadings, as well as see if it should wait or not. Let's see. And the Wayfarer people better be not playing, okay? They better come with it. So that will be on Friday. And now, yes, the New York Times has filed against Wayfarer Studios, and I will be covering that as soon as I have time to collect my thoughts, read through everything, and see what's popping here. But I already know. This is wild. They should have just took the W. They should have just took the win, the New York Times. But no, it wasn't good enough. And now I feel like they've just opened a whole can of worms that the Wayfarer people can now really introduce the evidence. Whatever they got in the depositions, the metadata, the proof, Megan Twohey's own words against her, how she scoured thousands of pages, but yet y'all did that in 12 hours. They're asking for trouble on this. I don't know what they were thinking. We'll get into it in another video. But for today, and for sake of time, that's it, okay? Drop your comments. Let me know what y'all think about this. I will definitely be on that call Friday. And I will be here tomorrow. I'm going to break down everything from the New York Times tonight and get back to you about that tomorrow. But that's everything. Yeah, let me know what you think. In my opinion, it seems like Blake Lively is... she may have won some battles, but she is going to lose the war. You feel me? And I don't think that they got anything. I think they're scouring, and I think the Wayfarer people took them by surprise with this judgment. So we'll see. We'll see what happens on Friday. Okay? I hope you're having a good day. Enjoy your time. Please, please, please keep your hearts and your souls and your minds open. And as much as we can, love thy neighbor. And the world needs a little bit more love. That's it. And it all starts with us and loving ourselves even more every single day. And I hope tonight you can cherish your loved ones and love yourself a little bit more than you did yesterday. I love you, and I'm so happy that you're here, and I will talk to you soon. Bye.